I'm David Marcus, senior writer at The Deal, at our corporate governance event in New York with Jeff Marell, co-head of M&A at Paul Weiss in New York. Jeff, two important decisions on appraisal came down from the Delaware Court of Chancery in late May, Petsmart and SWS. Let's take each of those and talk about them a bit. First of all, Petsmart.
Well, Petsmart is an interesting case, right? We've had quite a rise in the number of appraisal cases that are out there, and I think this will give some pause to people who are pursuing these actions. The court decided that there had been a really robust sales process, and that led them to conclude that the deal price was really the best indicator of the fair value of the company. And so, there was no upside to people pursuing appraisal in that case.
And also in the last footnote, Vice Chancellor Slights, the judge in the case, suggested that this is an approach that courts should very strongly consider.
Absolutely. I think it's also a recognition of the fact that while courts often look to DCF valuations, which are based off of management projections, that particularly in a sale process, projections are often prepared with an eye toward being robust, being aggressive, because you're in a sell side mode and the buyer can do with it what it wishes with those projections, but that the projections in and of themselves are not necessarily indicative of how one should think about the value of the company on an unaffected basis.
And then the second case, SWS Group.
Yeah, another interesting set of facts really that drives part of the outcome there. Right there, as opposed to Petsmart, where you had a really robust sale process, a really robust market check, there you had a scenario where the acquirer had also been a lender to the company, had an ability to veto potentially other transactions, and there you didn't have the same robust sales process, and the court chose to look at the DCF valuations, and interestingly came to the conclusion that the DCF valuation would yield a value for the company that less than the transaction price. I think it was actually 8% less than the transaction price.
And so how do these two cases fit into the larger body of law on appraisal, and how might they change an approach that a stockholder might take to appraisal?
I think it has the potential to diminish the frequency with which people pursue appraisal actions. I think you've got courts basically telling you at one level, if you have a robust sale process, that they're going to defer to that's indicative of being able to discover the fair value of a company, and in the recognition that things like projections are potentially prepared with an eye toward a sale, that there's some robustness perhaps baked into them, and that they're not necessarily going to be the be-all and end-all of how one should think about valuation. So I think they have the potential to diminish the likelihood and the frequency with which people pursue appraisal.
Jeff, thanks for joining us.
Thank you.